Now on the docket, a major new development in the deadly 2020 shooting of Breonna Taylor. She's the Louisville woman killed when police burst into her apartment in connection with a drug investigation, opening fire after Taylor's boyfriend shot at them. Yesterday, a federal judge dropped the felony counts against 2 of the 4 officers charged in the case. Former police detective Joshua Janes and former Sergeant Kyle Meany weren't present during the raid, but federal prosecutors accused them of falsely obtaining the no-knock warrant that authorized the search. The 2 men are still facing lesser charges, but gone is the possibility of serious prison time for them. Breonna Taylor's family called this news devastating. They issued a statement that reads, in part, quote, "The assistant United States attorneys on the case have informed us of their plan to appeal. The only thing we can do at this point is continue to be patient. The appeal will extend the life of the case, but as we've always maintained, we will continue to fight until we get full justice for Breonna Taylor." Joining me now to talk about the ruling is federal criminal defense attorney Mark Reichel. Mark, thanks so much. The big headline here is the judge said Breonna Taylor's boyfriend caused her death and not the 2 now former officers. These officers are accused of falsifying that warrant that led to police wrongly showing up at Breonna Taylor's apartment in the first place. You have extensive experience when it comes to search warrants. You argued a case in front of the U.S. Supreme Court about search warrants, about the 4th Amendment, so you know what you're talking about, which is why we came to you, because help us make sense of this ruling. Really walk us through this argument that was put forward by this judge.
Okay, this is actually a really complex federal legal issue. I always tell everyone, federal court is about 1 step removed from the powdered wigs. It's very formal, okay? Now, here, these are not the officers that pulled the trigger. These are officers that stayed back. They got the warrant issued by lying about things. But they were charged not just with, they're charged with a violation of the law by getting a warrant based on false information. But later, the officers went in, killed this woman. So they're charged with almost like murder in a way by giving a bad warrant. But the judge here found that the way the indictment was written, there were some flaws in it. If they clean up this indictment, they can refile these exact charges. The judge just said this statute specifically requires you to allege certain things. Those weren't alleged, so I'm dismissing these counts in the indictment without prejudice. We all know what that means. Without prejudice legally means they can refile. Additionally, other counts stayed. The conspiracy to cover things up, to lie to investigators after that, those do carry federal sentences up to 10 years. So they're still charged with every other count in the indictment, but the main one, that they're false statements. What they did in getting these warrants resulted in the death, and therefore they should also get life imprisonment, was knocked out by the judge. So they can refile that, but it's still going to be a big hurdle in the future. And here's why. The judge said this was a superseding cause that, although it was foreseeable, we don't punish people for something that is a real superseding cause. And by Breonna Taylor's boyfriend firing first at these officers, that's this superseding cause that kind of cuts in the middle of what these officers who got the warrant did wrong. It cuts that off in a way, and it's a new cause. So when these other officers fired and killed her, that's something that they should not be held responsible for just by falsely getting this warrant.
But Mark, that's where the confusion is. And I've got to tell you, after this came out, I've talked about this with coworkers here. And really, that's where things get tricky, because initially Taylor's boyfriend, Kenneth Walker, he was charged with attempted murder of a police officer. That charge ended up being dropped, and that's because Walker's lawyers argued that Walker thought the people entering the apartment were intruders and not police officers, which is why he fired his gun in the first place. So help me follow this logic, right? Kenneth Walker fired that shot because he thought he was defending himself and Taylor from a home invasion. So those charges were dropped. But now the judge is saying his actions are to blame for her death. All the while, other officers charged in connection to her death have either pleaded guilty or they're facing trial. How can all of these elements of blame be true all at the same time?
That's very accurate. When each person advocates for themselves, they bring up a position, and if the court buys it, it's going to affect the other person's advocacy of their position. But remember, Mr. Hankinson, the other officer, he's going to go to trial again, I think, in October, and he's the one that pulled the trigger. He's separate. His case resulted in a hung jury. He's going to go to trial again. Now, these are the officers that stayed behind that did the false warrant and then covered it up afterwards.
Sure.
So here, yes, we all agree that the boyfriend's shooting was justified. There's no one who disputes that. Nevertheless, that's such a legally significant event that the officers that fired in the house were wrong. However, you can't hook that onto the officers who stayed behind and did the illegal act of making a false warrant. So this was a stretch. By the way, the judge did rule that if they refile it a certain way, they can take it to trial and argue it with a jury. The judge kind of gave their opinion that they don't think it's going to be successful in front of a jury. But the U.S. Attorney's Office can refile these exact charges.
So the judge, in this case, Western Kentucky Circuit Court Judge Charles Simpson, dismissed, as you mentioned, some of the felony charges. These were the most serious charges against these officers. What recourse at this point, then, do prosecutors have for holding these officers accountable moving forward?
They can actually refile the indictment and put allegations, specific allegations, more allegations in the indictment and track the language of the statute better. And it'd probably get by the same motion to dismiss, and the judge will say, okay, you can take it to trial now. This was something saying we want this to prevent it from going to trial because the language of the indictment is missing some magical words. Something hard to believe, but that's what the judge ruled. And I think they can cure it. Whether they can convict is a totally different issue. But the bottom line here, again, is what we really need to do and focus on at the federal level. These no-knock warrants just are a thing of the past, really. Circumstances. I argued in the U.S. Supreme Court about whether officers have to give you a copy of the warrant at the outset of the search, because it's not written in the text of the Fourth Amendment. So the Supreme Court at the time to give you a copy of the warrant at the outset of the search. We all know they knock on the door. You say, can I see the warrant? If they give it to you, boy, it's going to be a much more civilized, interaction that takes place. But if they won't give it to you, half the time people don't be there.
Yeah, they don't know what this is, right? Federal criminal defense attorney Mark Reichel, yes. Thank you so much for your insight, for your time. We will be sure to have you back on the show when this case gets further on down the way.